Hello members, welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. Today we are hosting a legal genius. I hope most of you know him. He is called Kalema Hamza, one of the best tutors of law that we have in our generation. And it's a great honor to welcome him today and to take us through the topic of matrimonial property, family law. Welcome, Hamza.
Thank you very much, my brother, for this opportunity to share knowledge with the viewers of Agora Legis. Indeed, it is priceless to share what God gave you. And my name is Hamza Kalema. I'm a colleague. We are brothers. Thank you very much for the invite.
Thank you so much. So, Counsel, our viewers today are expecting to hear more about matrimonial property in family law. What are the basis or the basics, the general points that they should know under that particular topic?
Thank you very much. So the law of matrimonial property is under family law, and by the end of this session, our dear viewers must understand what is meant by the term matrimonial property. They must understand how is matrimonial property apportioned. They should also understand the locus classicus cases under matrimonial property. Then again, they should understand indeed how to answer an exam of matrimonial property. And primarily, they should understand that matrimonial property comes after divorce proceedings.
Thank you so much.
Thank you very much.
So, Counsel, one by one in those top points that you have mentioned, take us through briefly what is the meaning and how to identify matrimonial property, of course, with legal authorities for the viewers.
Thank you very much. And indeed, for every viewer who is watching, I urge you to subscribe, share, like and comment, turn on the notification such that whenever new videos are released, they shall be brought to your attention. So to begin with, if you are to understand matrimonial property, you need to understand the case of Ambayo Joseph Waigo versus Aselwa Jaclyn. It is Civil Appeal number 100 of 2015. Judgment of Justice Muzami Uchibedi, Elizabeth Musoke, and Christopher Gashoyabake. Indeed, it is an appeal from the High Court. You know, this case was burning later on in 2015 because it opened our eyes. Most of us have that fixed mind that the apportionment of matrimonial property is an automatic 50-50 share. That's actually the judgment of Justice Bamugemeleire in the judgment of the High Court in the same case of Ambayo Robert versus Jaclyn Aselwa. Because for her, she said that the lady and the husband and the wife must take an equal 50-50 share, following Article 31, Clause 1 of the 1995 Constitution, which clearly states that husband and wife shall have a right to marriage and to found a family, and again, equal rights in marriage and its dissolution. That's why she said the wife now had 50% share of the value of which that property should be given to her. Then the man 50%. But if I'm to take you through briefly the facts of that case, Ambayo Joseph Waigo and Jaclyn started cohabiting in 1989. So the two even produced children before marriage, before their church marriage in 2005. So during the time, Joseph paid for Jaclyn's education in primary school. Joseph paid for higher education in secondary level, even her driving skills. Then again, in the same time, Joseph purchased a plot of land and he built a matrimonial home now. We are now talking about matrimonial property, matrimonial home. Remember, they are just cohabiting, and that plot of land was put solely in Joseph's names. So the question is now, my brother, if I put my property in my names, can my wife share it? Hang on, you're going to understand that. So now, they later on legalized their marriage. They went for church marriage. So after their church marriage now, as human beings, they got some misunderstandings on the way, because Joseph accused Jaclyn for adultery with a man in the driving school. So he went and petitioned the High Court for divorce. The High Court granted divorce, but now the contention of the High Court was on the apportionment of matrimonial property. So that is the question where Justice Bamugemereire stated that whereas the contract upon which the matrimonial home was standing or stood was in Joseph's name alone, the house nevertheless belonged to the two spouses, and that Jaclyn was entitled to an automatic 50% share
of
that house, the value of which was to be given to her. So Joseph was not contented with what Justice Bamugemereire ruled, because remember, Jaclyn talked about, or while in court, pointed on the unpaid care work, the work she was according to Joseph, the emotional support, taking care of the children, and indeed she said even in the building of the house, she used to assist the builders, the workers. She even gave some little money. In law we call that unpaid care work. And it directly accounts, or it's considered when we are apportioning matrimonial property. Now Joseph appealed to the Court of Appeal, because for him he was not satisfied with the automatic 50 to 50% share. Now in the High Court, Justice Muzamiru Kibedi clearly brought back Article 31 Clause 1 of the 1995 Constitution, which is in essence provide for equality in marriage and its dissolution. But however, Justice Muzamiru Kibedi stated that it is not synonymous, it is not automatic that each of the spouses should get an automatic 50 to 50 share. We have to see where were you strong. Like now, for example, we can look at the High Court looked at the unpaid care work of Jaclyn. But Justice Muzamiru Kibedi stated that it was erroneous for the High Court not to account, not to consider Joseph's money he used to educate the wife in the primary school, educate the wife in the secondary school, and even the driving school.
Exactly.
So for him, it was like the quantum of the unpaid care work of the woman was reduced by what Joseph had paid for her school fees, even health care. So indeed, this case was decided Paturiam. Paturiam means all the three judges agreed, unanimously agreed that these people
on the same decision.
They agreed on the same decision. That was Justice Muzamiru Kibedi, Christopher Gashirawake, and Elizabeth Soke. They unanimously agreed that Joseph shall take 70%, then the wife 20%. So at the end of the day, our dear viewers, you must know that the share of matrimonial property is not an automatic 50 to 50 share. I urge you to look at that case of Joseph Waigo versus Aselwa Jaclyn. Thank you very much for watching. The microphone is yours, my brother, maybe to clarify on anything.
Yeah, thank you so much, Counsel. We still have one area of contention that we are having. After understanding the nature of matrimonial property in law, in family law, what is the place of contribution as a measure of who is to take what while distributing matrimonial property? Because you have talked about the fact that someone could contribute in a way that is not monetary.
Yeah.
So how does the court examine who is to take what and at what percentage?
Thank you very much. And indeed, in the similar case, it was clearly stated that the contribution to matrimonial property may be monetary or not. So it means that if you're to petition the High Court for share of matrimonial property, that's why I told you it's followed by divorce, a decree, nullity. But your question is, how is this thing calculated? It is put into money's worth. We call it money's worth. We determine its value and convert it into money's worth. Because take an example, you have a wife at home, though you don't have one right now. So there are days you have that emotional disorder. She will care for you and you will lose that. So do you pay her for that? And how much can you pay for that?
Exactly.
So that shall be put into money's worth.
So that means that there will be a process of valuation.
A process of
whatever
valuation.
contribution was put into the matrimonial property.
Yes, thank you very much.
So members, I hope you have grasped the principle. It is really an honor to hear from Counsel Kalema Hamza. I urge you to go and look at the additional case of Mwanga vs. Chintu, which also explores very well this principle on matrimonial property. I urge you to like, subscribe and share. That is it for today. Thank you for watching, and it's always Agora Legis with Counsel Ben, and it has been a pleasure to see Counsel Hamza with us today. Thank you for watching.